Welcome to today's webinar on oil and gas law. Now, I have to tell you a joke about Boudreaux and Thibodeau, because Boudreaux and Thibodeau, you see, Thibodeau owned an oil and gas company, okay? And Thibodeau owned an oil and gas company, and Thibodeau placed an ad in his window, help wanted. And wouldn't you know it, here comes Boudreaux. So Thibodeau said, oh man, what I'm going to do, I can't have that Boudreaux come over here and work for me. He's too dumb, him. So what I tell you, I'm going to have to devise an employment quiz for him. That's what I'm going to do, and I'm going to make it real tricky. So Boudreaux comes into the office, and Thibodeau says, oh, Boudreaux, man, I'm so happy for you to see me. He says, listen, I know you're interested in the job, but we got a little employment test that we take here just to make sure the applicants are qualified, to be a landman or a land professional or a division order analyst. You got to be good, Boudreaux. You got to be good with numbers. You got to understand how numbers work. So he says, have a seat, and we'll just take out a piece of paper right here. And if you will just write for me, what I want you to do, Boudreaux, is I want you to represent the number 3 without using any numerals. Oh, so Boudreaux had to think about that, man, how he's going to show the number 3 without using any numerals. So this is what he draws on his paper. He said, man, I know how to do that. And this is what he draws on his paper. And Thibodeau said, man, what the hell is that? He said, well, you told me to represent the number 3 without using any numerals. That's a tree, 1, 2, tree. And so Thibodeau goes, oh my God, this guy, he's driving me crazy. So I'm going to have to pick something a little bit trickier than just tree, because he drew me a tree. He says, okay, Boudreaux, that was very good. He said, now I want you to represent the numeral 33 without using any numerals. Oh, man, now Boudreaux had to think about that. Now, he couldn't draw 33 trees. I mean, I guess he could, but that was going to take too long. But then all of a sudden, he got an idea. And this is what he drew on his paper. And Thibodeau looked at that, and he said, man, Boudreaux, what that you drew on there? And Boudreaux says, oh, man, that's some dirt. That's a dirty tree. Thibodeau couldn't believe it. He said, man, I got to catch this person. I mean, he's nailing this test. So he says, okay, Boudreaux, you're doing real good on this test, real good. He says, but, if you want to be a division order analyst or a landman, you got to be able to equal 100. You got to know your fractions. You got to know how to add up to the number 1. So all the mineral owners will get their share. Thibodeau says, oh, my God, I'm going to show the numeral 33 and a half. So he taught and he taught and he taught. And then he said, I got it. He said this is what he drew on his paper. And he drew a little circle at the bottom of each of those little trees. And he said, there you go, Thibodeau. There's your dirty tree. There's 100. So he's like, what? How could that be 100? He said, well, a little dog came along and he pooped at the bottom of those trees. That's dirty tree and a turd, dirty tree and a turd, dirty tree and a turd. Now that equals 100. When do I start the job? Oh, good. They all liked it. I can hear the laughter from here. Okay, so what we're going to talk about today, ladies and gentlemen, is oil and gas law. Now, I want you to have a basic understanding of the law to do the work that you're doing. So this is designed to show you kind of a simulation, a 1-hour summary of what is taught in a law school class to get an understanding of oil and gas law. And in fact, on the Texas bar exam, oil and gas law is on the Texas bar exam. Not true in Louisiana, but that's how important minerals are to the state of Texas. So I want you to be aware of the general concepts and principles of oil and gas law. Now, our little drawing here is appropriate because a lot of times people will refer to rights in land as a bundle of sticks, or ownership as a bundle of sticks. And these are each supposed to be little sticks, but I'm not that good a drawer. Okay, and so what they mean by that this bundle of sticks, is that it can be owned in many different ways. It can be owned as a surface estate. It can be owned as a mineral estate. It can be owned as a royalty interest. It can be owned as an overriding royalty interest. It can be owned as a non-participating royalty interest. Non-participating royalty interest. It could be leased. It can be mortgaged. It can be sold. So what we're saying basically is that when you have ownership of land, that encompasses more than just your right to buy and sell that land. It also gives you rights to create separate sticks, separate bundles, not bundles, but separate sticks. So you'll hear people refer to ownership as a bundle of sticks. So that's the first thing I want you to recognize, is that ownership, land can be owned in many different ways, and you can have many different relations to the land and ownership in the land. So let's look at our outline for today. We're going to start with ownership of oil and gas. Who owns the oil and gas under your property? And we're going to talk about an ancient ownership theory called the ad caelum doctrine. I want you to understand that's where we came from. That was our history. Then with the development of oil and gas, we turned to something called a rule of capture. And then I want to go over some of these ownership theories with you. Things like fugacious and fungible. And I also want to talk about how the rule of capture works. Some states are ownership in place, and some states are owners. So, and I'll go over that in a minute. But Texas is, I'm going to show you that in a minute. So the next thing I want you to recognize is what we call the doctrine of correlative rights. And what this says is it's kind of an exception to the rule of capture. But what it basically says is that everybody is responsible for keeping the reservoir whole, for letting everyone have a fair share of that revenue, of the reservoir. Then I want to talk to you about the rights of the mineral owner. The person that owns the minerals has certain rights under the law, and I want to go over those with you. And then I want to go over what happens legally if the rights of the mineral owner are trespassed in some way, or trespassed or encumbered upon. And we'll talk about what those lawsuits would look like. And then I'm going to briefly go over implied covenants of the lease, because we're going to have a separate webinar on that. But I just want to mention it to you here because in all my research, they almost always included implied covenants of the lease in the oil and gas law section. So I want to just briefly go over those. Okay, so let's look at ownership of minerals. Now, a long time ago, there was a common law principle that said whoever owns the land, whoever owns the soil, it is theirs all the way up to heaven and hell. So it's also called the heaven and hell principle. I can say it in Latin for you: Quis est solum eius est usque ad caelum et ad inferos. And this is, could you think about celestial and think about an inferno being hell. So it's a heaven and hell way to look at your land ownership. You own all the way to the sky, all the way to the heavens is your ownership. And you own all the way to the depths of the earth, to the core of the earth. That is your ownership. And this is the principle that we still use today for hard minerals. But in the case of Del Monte versus Last Chance Mining, this is just an example of this rule. Last Chance was the defendant, and he followed the mineral vein. Now, it was silver, not oil and gas, and went beyond the boundaries of his own property. Okay, it was still the same silver vein that started on his property, but he crossed the line. And so the court held that the owner of the fee of the soil owns all below the surface, limited by the extent of the surface rights. And so what the court is saying is that you can't follow that vein into someone else's property. Yes, you own everything from the heavens to the earth, but you don't own your neighbor's property, and therefore you have no right to go exploring for it, even if it is the silver vein started on your property. Now, this all worked great until the invention of the airplane. You see, this is an 1898 case. And so the question is, how much of the airspace do you control? You know, do planes have to get your permission to cross your airspace? And the answer is, you're entitled to as much of the airspace as you can reasonably use. So we really can't use any of the of our property in the solar system, for example, or the moon. So it's only as much as you can reasonably use. So the minerals, however, this works for hard minerals. Is the owner of the soil entitled to the minerals under his property? Yes, if the minerals are solid, okay? But when we're dealing with oil and gas, we know that it is not solid. Oil and gas moves. It's fugacious is the technical term for it. And what fugacious means is that oil is in between these rocks. Okay, and you have oil on your land, I have oil on my land. And that oil will move. If I drill a well on my land, the oil from your land is going to move toward my land because of pressure. And there's no way for us to look at the oil that comes out of the ground and say, oh, well, this was from his property or this was from their property. So we say that it's fungible. That is, one can replace another. They're not unique. An example in law school that they gave us was a bushel of wheat. If you say, I'd like to buy a bushel of wheat, and they deliver the bushel of wheat and you paid for it, and you said, no, this isn't the one I wanted, they're going to say, look, they're all the same. Okay, there's nothing unique about this particular bushel of wheat. If you wanted that bushel of wheat, you should have specified that. So oil and gas is fugacious and it's fungible, meaning there's no way to tell who owns what once the oil comes out of the ground. And that's different from hard minerals, which remain in the ground. If you have a silver vein going through here, and let's say you have a silver vein going through here, and I drill on my land for whatever, or find a silver vein, it's not going to deplete your silver vein. So the hard minerals stay on your land, but oil and gas moves, and it moves based on where the pressure is. So they had to come up with something that was unique for oil and gas. They had to come up with a separate law for oil and gas minerals that would not work with hard minerals. And what they said was they came up with something called the rule of capture. And what they're basically saying is the landowner who extracts oil and gas from beneath his land acquires absolute ownership of those extracted substances, even though they may be drained from beneath the land of another. So in the previous slide, if we drill a well here and this oil starts flowing this way, that whoever drilled it is entitled to all the oil that they can get, regardless of whether it came from an adjacent neighbor's land. And if you think about it, like if you go duck hunting, for example, and let's say you're duck hunting on your property, or let's say a duck passes in front of your house, and who owns that duck? Well, we all own it, right? It belongs to the world. It belongs to mankind. But if you shoot that duck, then who owns the duck? Well, clearly it's the person that shot the duck. They are going to take it home and they're going to make a delicious duck gumbo. And that is their right because they are the owner of the property because they are the ones that captured it. So that's how we got the rule of capture. They based it on the current law of wild animals at the time and still is today. So the rule of capture is if you drill it on your property, you are entitled to 100% of the oil that comes out of the ground, even though you may be draining your neighbor's property. So I just want to let that sink in for a minute. I want everyone to understand that that is the rule of capture. Now, there are certain exceptions. Let me do this first. So let me give you a hypothetical. This is on page 9. I'm skipping ahead one slide because I want to emphasize what the rule of capture is. This is the hypothetical. This is something they might throw out to you at in law school. So we have a landowner who owns 10 acres of land. If she drills an oil well on her 10 acres, it's going to drain oil from a 40-acre radius. Okay, she only has 10 acres. She owns 10 acres outright, not leased. She owns them. If she drills a gas well on her 10 acres, it will drain gas from a 640-acre radius. So she has 10 acres. She drills on her land. She's going to drain the oil and gas. For oil, she's going to drain the other neighbors who maybe own the 30 acres. And she's going to be able to get all that oil and gas because she owned the 10 acres. So the question is, the landowner drills a well. Do any of her drained neighbors have a right to share in production from this well? And the answer is no, because of the rule of capture. She has not signed an oil and gas lease. There's no pooling provision in the lease that she's subject to. So yes, she can drill and drain her neighbor's interest. Can the neighbors get an injunction to shut in her well? Your Honor, she is draining the land from my property. I know I have oil and gas under my property. We've shot seismic. We know it's there. Therefore, she needs to stop producing or she's going to drain all the oil and gas from my property. The judge is going to say, sorry, rule of capture. Can the neighbors seek damages for drainage? Okay, maybe we can't stop her, but she is damaging our reservoir. She is causing harm to it because she's depleting it. So, Your Honor, in lieu of an injunction to stop it, can we receive damages, a certain sum of money to compensate us for the oil and gas that she's taking out of the ground? And the answer is no. You know, there's no pooling. There's no sharing of production because there's no lease. Okay? So what do you do if you are being drained by your neighbor? The only remedy you have is self-help. The adjacent landowner's only remedy to protect her land is to drill her own well so that then she can recover the amount of her property. Now, as an aside, you will recall when we were talking about pooling, this is why in those early pictures of oil and gas, you saw well after well after well after well after well because you didn't want to be drained by this guy's well and your only remedy was to drill your own well. Now, that all changed once state spacing regulations went into place, but rule of capture caused this overly dense populations of oil and gas wells. It caused all the damage that then resulted from pooling. Now, I always get a question here about, can a landowner really drill under state spacing regulations? This landowner is going to have to apply for a spacing, is going to have to apply for a well permit. And they are going to have to get permission from the Railroad Commission to drill on 10 acres only. That means their tract is not going to meet, let's say the state guidelines is 40 for oil. She's not going to meet that state spacing guideline, so she's going to apply for an exception. There's a special exception for small mineral owners or mineral owners, and there are plenty of tracts in Texas that are as small as 10 acres. So the Railroad Commission we'll take that to consideration. But the bottom line is, if you own the land, you have the absolute right to drill on that land, subject to state regulations, of course, but you have the right to drill on that land, even if it's only 10 acres. So there's different ownership. Oh, let me go back. Sorry. There's exceptions to the rule of capture, and one of them is if you drain oil and gas that is produced in violation of a commission order. In other words, the commission regulates drilling and production. I'm talking Texas now. Drilling and production from wells. And what they do is they set production guidelines. They set, you know, you can only produce this much oil and gas a day. You can only produce this much oil and gas a week. You can only produce this much oil and gas a month. You can only produce this much oil and gas annually. That is what the Railroad Commission does. So they want to make sure that if you have someone that is draining your property, that you can, that person is not going to overproduce the property so that it'll cause maybe reservoir damage or some kind of problem to the well. They can legally drain your oil and gas, but they can't do it if it violates the state producing guidelines. Also, there's an exception to the rule of capture. You can't illegally capture. So, Your Honor, I'm putting this on my property. It's my well. I have the absolute right to drill and develop it if it's on my property. That's true, but you can't then do horizontal drilling and have that well go onto someone else's property and then argue rule of capture. That is not going to work in court. So you have to stay on your own property. You can't go into someone else's property. Another example is a negligent blowout. If I can find that example. And what happens in a blowout is there is some problem. An oil company drilling in adjacent land acts negligently and causes a blowout. And as many of you may know, that's an explosive, uncontrolled release of oil or gas under high pressure. And it usually results in large losses of oil and gas. And of course, it's very difficult to contain because it's constantly being fed, the fire is constantly being fed gas. So it's a very difficult situation. There was a case called Champlain. Oh, that's not the right one. But that is a negligent blowout. I'm sorry. The case is Kelly v. Ohio Oil that talks about an operator that caused a blowout and caused damage. The rule of capture does not apply. The rule of capture does not allow you to waste our precious natural resources. So that is an exception to the rule of capture. You can't say, Your Honor, it's my property, and under the rule of capture, I can do whatever I want with my land. No, that is not what the rule of capture says. The rule of capture says you have the right to drill on your land, and whatever you produce, you own. You do not have the right to cause a blowout. The second exception is stored gas. This is a case called Champlain Exploration versus Western Bridge. And what it says is that extracted oil and gas, which are stored in underground reservoirs, are considered personal property rather than an interest in real property. So let's say that you own land, and maybe it's got this this empty reservoir on it. A lot of times it's in a salt dome. And Exxon approaches you and they say, hey, we've got all this production from this well over here. Can we store it in your underground reservoir? Can we store it in that salt dome? And you say, sure, for a cost. So you negotiate out a rate, and then Exxon can then store their gas on your property. Now, does that mean that when Exxon takes the property out of the reservoir, that you get a cut of the royalty? And the answer is no. It does not. The rule of capture does not apply for stored gas. If someone gets permission from you to store gas on your land, and then they remove that gas or oil at some later point, then you do not have the right to any of that. So that's another exception for the rule of capture. How am I doing? Raise your hand if you think I'm doing okay. Okay, there's only one hand up. Okay, just want to make sure y'all are catching up with me here. Okay, so now I already went over that one. So now there's two different ownership theories by state. Now this kept coming up in my research, and personally, I don't see that it really makes a big difference. But what it says is that there's different ownership theories by state. Texas, for example, is an ownership in place. It says you actually own the minerals under your property. The other theory is the non-ownership theory, and it's in a place like Louisiana. And what it says is you don't own the minerals. You own the right to take the minerals. I really don't know what difference it makes, but all you need to know is that the rule of capture applies regardless of what the state theory is. So rule of capture applies in Texas, rule of capture applies in Louisiana. But this rule of capture is balanced against what we call correlative rights. Correlative rights, it balances out the rule of capture because it says, yes, you have the right to drill on your own property, but you don't have the right to cause damage to the common reservoir. So we all have to be good stewards of the land. And we have to take into consideration the other people that have a right to drilling of the property. So you saw what the correlative rights does is we're trying to prevent waste, okay? And what this means is you do not have the right to blow it out. You do not have the right to waste those resources. The second correlative right is you do not have the right to spoil the reservoir. So as an example is if you have a water-bearing zone, which is a common source of supply, so a bunch of people own in it. It's known in the industry that there's, and let's say it's known in the industry that there's a very fragile sealing rod, which could crack your well and cause water to come into the formation. ABC Drilling comes along and they ignore this commonly known information and they cause the water to come into the formation, thus potentially spoiling the oil and gas. ABC is liable for spoiling the common source of supply. Even though they did it on their own property, you do not have the right to damage the reservoir in any way because of the doctrine of correlative rights. You have to take into consideration the other people that have rights in the other people that have rights in the reservoir. Sorry. Okay, so everyone's got that. This is how the rule of capture is balanced. You can't waste it, you can't spoil it, and you have to observe valid conservation orders. That is what the Texas Railroad Commission sets forth. You have to have only one well for so many acres for oil and one well for so many acres for gas. You have to observe those conservation laws, because we want to balance the rule of capture against the situation where we used to have where we had derrick after derrick after derrick. And that's what these pooling laws do, these state spacing laws do. So you have to observe the conservation measures. You can't just say, well, I'm an island, this is my property, I'm going to do what I want with it. No. The Texas Railroad Commission monitors all oil and gas activity in the state. So in order to drill a well, you have to get a permit from them or you're going to be in violation of state law. Okay. So what's happening basically is that in this Wronski versus Sun Oil case, this is when the exception to the rule of capture came in, and that is that the rule of capture excludes operations that are in violation of valid conservation orders. So you cannot overproduce it, even though it's on your own property. You cannot cause damage to it. You cannot waste it. And the reason that we have this rule, this fair share rule or fair share principle, is it's a matter of fairness. You know, we all own property in this land, and therefore if one person damages it, we all lose. You don't have the right to do that. It prevents reasonably avoidable drainage. You know, there's such a thing as pressure in the well, and if you are overproducing your property, then you could cause a damage to that reservoir. So we're trying to prevent damage to the common reservoir. So what we have, rule of capture is now balanced against the correlative rights and the fair share principle. Okay, so now let's look at the rights of the mineral owners beyond their right to drill on their land. Now, the mineral owner has what's called the right to receive, the right to execute, and the right to use the surface. So they have the right to receive bonus payments, delay rental payments, and royalties. That is what they are entitled. If you own the minerals, you're entitled to the bonus. Who we're going to pay the delay rentals to? The mineral owner. Who gets the royalties? The mineral owner under an oil and gas lease. You have the right to execute, also known as the executory right, which means if you own it, you are the proper person to sign that oil and gas lease. No one can sign for you. You have the right to execute it. The non-participating royalty interest owner does not have a right to execute. They own a royalty interest, but they don't have the right to grant an oil and gas lease. So they're never going to get the bonus. A non-participating royalty interest is never going to get the bonus because only the mineral owner can execute oil and gas mineral leases. Now, the other right of the mineral owner is somewhat controversial, and that is that the mineral owner also has the right to use the surface as is reasonably necessary to develop the minerals. Now, does this mean we cannot use our own land? If you own the surface and the minerals, you are fine. This occurs in the case where there is a severed interest. A severed interest. And what a severed interest is that owner A owns the surface and owner B owns the minerals under the ground. So this is the surface owner and this is the mineral owner. Okay, now how does that happen? Well, let's say that we own property and we want to sell it, but we want to keep the minerals. You know, we want to keep the mineral rights. So what we're going to do is we're going to sell, let's say B is going to sell their property to A. He's going to say surface only. You all may have seen that in some of the deeds you were running title to. Surface only. So what does A own? A owns the surface. What does B own? B owns the minerals. And that is how one person can be the surface owner and a different person can be the mineral owner. Now, here's what's tricky. Here's what is controversial. And that is under oil and gas law, if one person owns the surface and another person owns the minerals, the mineral estate is dominant. That means that we can put a rig on this property, on this surface, without the consent of the surface owner. Why? Because the mineral estate is dominant. So let's look at that. The dominant mineral estate, this was established in a case called Hunt Oil versus Kerbaugh. And what it says is that if one person owns the surface and one person owns the minerals, that is, the mineral estate is severed from the surface estate, the mineral estate is dominant. So B's rights trump A's rights. Now, it's limited to the surface that is reasonably necessary to explore for and develop minerals. You can't just take it over and start, farming on their land. But if it's for mineral development, for oil and gas development, you can, as B, you have superior rights over A. And you can agree to let someone come onto A's surface and shoot seismic. you can agree to have someone come on A's surface and drill a well. And I don't know if you remember, I think I'm going to put a DVD on there, but what do they do to prepare a site for the well? It's massive. I mean, it's a huge concrete pad that they put down. There's roads going in, there's roads going out. I mean, it is an operation, not to mention the noise of the thing. So as an example, if you want to shoot seismic on somebody's property, who do you get permission from? And the answer is you get permission from the mineral owner, because the mineral owner's rights are dominant. So what the law says is basically A has the right to use that surface. B has the right to use that surface no matter what it does to A's, as long as the use is reasonable. Does A get any compensation for that? Under the law, A really is not entitled to any compensation. The law says that B's rights are dominant. Now let's look at why a state would impose a law. Why did this court decide that? Is that fair? Are we really being fair to this surface owner? Well, if you own the surface and you did not own the minerals, and an oil and gas company wanted to come and drill on the land, but you were not going to get a share of it because you were not the mineral owner, what's the likelihood that this surface owner is going to give us permission to come onto their land and put this huge concrete pad down and start drilling and have trucks coming in and prepare the roads? It's not likely. And so the state, remember, the state's common concern is that they want people to be self-sufficient. They don't want people having to depend on the state to support themselves and their families. So that's why we have this rule of the dominant mineral estate. A is never going to give us permission to drill on their property. And so we have to figure out a way to allow the mineral owners of the world to develop their minerals. And so the rule of law is if the minerals are severed, the dominant estate is the mineral estate, not the surface estate. Okay? Is everybody clear on that? I just want to make sure that we're understanding that. Now, do we sometimes pay A? And the answer is yes. We do pay A. We will sit down with A and negotiate with A, even though under the law we don't have to. Under the law, we are the dominant mineral owner. We are the dominant estate. We have a lease on that property. I don't need your permission, A, to drill on this property. But I will sit down with you and I will negotiate with you fair damages to your property. So why do we do that? Why would an oil and gas company agree to put more money out than they have to? And the reason is it's for public relations. Because imagine, if you will, a little old lady on 60 Minutes, and Mike Wallace is asking her, and what she's saying is, I own this land. This has been in my family for generations. And all of a sudden, this oil and gas company just shows up out of nowhere. And because I don't own the minerals, they have the right to put their property all over my property. It's keeping me awake at night. This is so unfair. What is going to be the oil and gas company's response to that? Well, under oil and gas law, you understand, Mike, the mineral estate is dominant. So therefore, the mineral estate, they're not going to understand that. They are going to have sympathy for the little old lady. So even though we don't have to pay the surface owner, we do as a gesture of goodwill and because we want to stay off of 60 Minutes. And the other reason is because we're going to have a long-term relationship with A. And if A is mad at us, they are going to make it very difficult for us to get on the land. I've heard stories of people coming out with guns, sending their dogs out. This is my property. You don't have the right to come on this property. Well, we do under the dominant mineral estate theory. So that's the other reason. We want to have good relations with the people that own with the lessors, and we want to have good relations with the surface owner. So we'll sit down with that surface owner and we'll say, well, we're going to put the pipeline here. Does that make sense? And, well, no, I'd rather you have the pipeline away from the cattle because if there's some kind of leak, okay, well, we'll put the pipeline here. And they will sit down and negotiate with that. They will give a sense of control, even though legally we don't have to do that. Now, I will tell you that there are certain states that have state statutes that do require that you pay the surface owner. So they have the dominant mineral estate, and yes, A cannot prevent you from coming onto this land, but you have to pay A. And those states are, pay A. Those states are like Oklahoma and New Mexico are two that I know of. This is why you have to know the laws of the state where you are. So in Texas, we don't have to pay the surface owner in order to drill on their land. But as I said, we're going to do it as a gesture of goodwill. Now, there are certain exceptions, as you can imagine, to the dominant mineral estate. And one is called the main one, I guess this is just one of them, is that it's called the accommodation doctrine. And it is a right that the surface owner has. And what it says is that, okay, yes, the mineral estate is the dominant estate, but you have to accommodate us. You have to prevent injury to our land if we can prove three things. One is that there was a pre-existing use of the surface. The other was that there is a reasonable alternative method available, and that alternative method is available on the lease tract itself. So let's say that Farmer Joe has grown cotton, his family has grown cotton for generations, and he only owns the surface, and Mary owns the minerals. And she's leased her interest to Big Oil. Big Oil has drilled producing wells on the tract. Both estates have existed peacefully. Then Big Oil needs to put pumping units on its wells to remove more oil because of the field's pressure. Now, these pumping units stand over 20 feet, and they are going to interfere with Farmer Brown's farming of this land because he has what's called a rolling irrigation system. And a rolling irrigation, I know y'all have seen these before, but it's like a hose that goes out, and the farmer is on a tractor, and there's these holes in here, and water is being supplied, and actually sometimes it works automatically. There's not a tractor, but it will roll across the field, roll, 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 and it will water all of Farmer Brown's crop. Now, if they put these pumping units on there, this expensive piece of machinery is not going to be able to work. So in the case of Texaco versus Getty, the court came up with the accommodation doctrine and said, look, you cannot cause damage to his crop if he can prove, hey, I've been using this for a long time. I've been using this before there was any interest in oil and gas. And he also noticed that other farmers in the area were having the wells put down or using cellar pits, and that lowered the height of the pumping unit. And using electrical versus mechanical pumping uses, which would also allow this rolling irrigation system to work. So in that case, in the case of Texaco v. Getty, they said, okay, this is an exception to the dominant mineral estate. If these things can be proved, then we have to give the surface owner these rights. We have to accommodate the surface owner. Now, let's use the same facts, but instead of using tall pumping units, Big Oil wants to use large amounts of water, fresh water, from an underground aquifer because he wants to repressure the field to recover more oil. Now, the fresh water on the property belongs to the surface owner, surface estate owner, but M, the mineral owner, has the right to use the surface, which includes using ground space using other substances like water that are part of the surface estate, unless the lease says he cannot do so. But again, the dominant mineral estate occurs here. Because if we need to use fresh water, we can do so under this provision. Okay. Other rights of the mineral owner. They have the right to develop their property without leasing. In other words, they have the right to be hired as an operator. Actually, not be hired, but they have a right to hire a contractor to come and drill on their land. They do not need to have an oil and gas company do it. They do not have to have a negotiation with an oil and gas lease to put a well on their property. Now, they have to abide by state spacing guidelines. So they have a right to develop it, but do they have a duty to develop it? Do you have a duty to develop the oil and gas lands under your property? And the answer is no. You know, if you currently own the minerals where your house is, the state cannot require you to drill on your land. So there's no duty to develop it. You have the right to develop it, but not the duty to develop it. Now, I want to talk about under duty to develop. I want to just briefly go over with you something in Louisiana law that is relevant here. And that is, in Louisiana, if you have a severed estate, one person owns the surface, the other person owns the minerals. The way it works in Louisiana, there's a law called prescription. Prescription. And what it says is, okay, A, you own the surface. B, you own the minerals. If the estate is severed, okay, one person owns one, the other person owns the other. B, the state of Louisiana will give you 10 years to develop that property. And if after the end of 10 years there is no production on that property, B, you lose your right to the minerals. And it reverts back to owner A so that the mineral estate is no longer severed. Okay, so in Louisiana, there is a duty to develop if you want to maintain your mineral rights if the interests are severed. Now, why does Louisiana have this crazy law? And the reason is it's very difficult, as many of you may know, to track title if one person owns the surface and one person owns the minerals. So we want you to keep it together so that it'll be easier for oil and gas companies to come here and drill. That's why they have the law. So we say, you got 10 years, buddy. And if you don't produce, it goes back to the surface owner. Now, this comes up in my family a lot because, as I said, we own some property in Opelousas, Louisiana, in St. Landry Parish. And, you know, my grandfather owned it. My parents own it. You know, they're going to pass it down to us. So, it's just going to stay in the family. So every now and then we'll have a family reunion, you know, and they'll say, man, you know what we should do? We should just sell the surface to someone, and then we'll keep the minerals. I mean, the mineral estate is dominant anyway, so at least right now we'll get some cash for selling the surface. And there's about 3 lawyers in our family, and we always gently remind them that, well, under Louisiana law, if you sever this, that puts a duty on us, the mineral owner, to develop it. And if in 10 years, which I don't have the equipment to develop it, I don't know how to drill a well, if we don't do it in 10 years, A gets everything. Okay, and A didn't even pay us for our mineral interest. So that's an idea that's just not going to work. That dog won't hunt, as my torts teacher used to say. So I just want you to understand that there really is no duty to develop, but in Louisiana they have this law called prescription. If you don't drill by a certain time, your rights prescribe, like expire, and it goes back to the surface owner. So there is a duty to develop. Now, let's talk about the situation in oil and gas law when there are co-tenants. Co-tenants, you'll recall, are more than one person who owns the land. So let's say it's my family's land in St. Landry Parish, Louisiana. All right, my grandfather and grandmother are both deceased, and they left the property to their 7 children. They left the property to their 7 children. So each of their children, my father and his brothers and sisters, each own a 1/7 interest. Okay? That means we own a share of the whole. If you'll think about it almost like a corporation. Okay? This is all the corporation. We own shares in the corporation. Now, let's say my uncle wants to drill a well. Uncle Albert wants to drill a well on the property, and no one else wants to drill a well. They all say, no, we're going to use this property for farming or for timber or for some other reason, or, oh, no, grandfather never wanted this to be used for oil and gas. It's just going to destroy the beauty of the place if you put an oil and gas well on there. Can my Uncle Albert sign an oil and gas lease and get, without the consent of the other kids? And the answer is yes. Under Prairie Oil and Gas Company versus Allen, every co-tenant can drill and produce or lease his undivided share without the consent of the other owners. Okay, so my daddy doesn't have to agree with my uncle, and my uncle still has the right to put that property on his land. Now, sometimes I get calls from people, and they'll say, I want to sell 2 acres to my daughter, in the northeast quarter. And so I have to tell them, look, you can't sell 2 acres because you don't own 2 acres. You certainly can't carve out where on the tract you want to give these 2 acres. All you can convey is your share of the property. That's why it's called an undivided interest, because you can't divide it out. So everybody gets their 1/7 share. Now, you do have to account to the others for their rightful share of the profits from production. Okay? So yes, Uncle Albert signed this lease and they drilled on the land, and Daddy didn't agree to it. But now the well is producing, and out of that well, all 7 people have to get paid out of that well. Okay? And they don't have to pay for it. They don't have to pay for the cost of drilling. That's how that works. So really the people that hold out are going to get a higher interest, because my Uncle Albert's going to get a 1/7 interest times whatever his royalty is, 3/16, let's say. And my dad is getting a 1/7 interest. So my dad's interest is a 0.142. And my uncle's interest is a 0.1, let's see, it's going to be 1.42 times 3%, or reduced by the 3/16. So that's going to be a lesser interest. And that's the way it works with co-tenancy. Any tenant can drill, any tenant can sign a lease, and that gives them the right to do what they want with their share of the land. Now, if you don't like this result, if you say this is ridiculous, I'm not going to participate in this, you can partition. It's called partitioning the property. And that is, you can file a lawsuit to partition the property, and that means then you can separate it out. So this is one person's 1/7, another 7. This is the one my dad owns. This is the one my Uncle Albert owns. So you can then separate it out by sale. And this was the case of Schnitt versus McKellar that said mineral interest may be the subject of a partition. Okay, let's see how we're doing here. All right, now you've heard of a life tenant. I know you've heard of a life tenant. This is what happens when Dad has money. Let's see, the husband and wife are married. And Dad doesn't want wife, when he dies, to go and marry someone else, and then they have children, and all of his money is going to go to these children and not to his own children. So the way he protects this from happening, when he dies, he doesn't give it to the wife outright, but he gives it to her as a life estate, meaning during your lifetime, you can use this land. Okay, but when you die, but you can't sell it to anybody else. If you get married, it doesn't become anybody else's property. But when you die, wife, the property is going to pass to the remaindermen, usually the kids. And that way the dad can make sure that the property is going to be maintained in the family. So the definition is one who holds an estate in land for the period of his own life or that of another certain person. So we need to take an oil and gas lease. Wife owns it as a life tenant. The son is the remainderman. So in other words, the son is one of these people. Can the wife grant a valid lease? Can the son grant a valid lease? And the answer is no and no. But if together they join, that's a valid lease. So as an abundance of caution, I would have both the life tenant and the mineral owner or the remainderman sign that document. Now, there is a law that says if there was a lease in existence before the life estate was created, so let's say he leased to Big Oil, way back here in the 20s, and it's still producing, or let's say it's just before he died, he signed a lease with an oil and gas company. Okay. So what would happen then is even though the wife is designated as a life tenant, if there was a lease in place when the life estate was created, then the life tenant is entitled to the payments under the lease. So they're entitled to the lease bonus, the delay rental, the royalty payment. And the remainderman, the son, owns nothing until mom dies. And then the son will get her share. So under the open mind doctrine, that ensures, or that allows the surviving spouse to support themselves, basically. It says that the lease was already in existence when the life estate was created. That's called an open mind lease, and it's under the open mind doctrine. The wife is going to get all the money because the lease was executed before the creation of the life tenant. Okay, there's certain kind of trespass. These are the lawsuit actions that would be taken, that a landowner would take against an oil company. One is ordinary trespass. So you have a valid oil and gas lease and your company forgets to pay the delay rental payment. That lease is completely void. You all know this, right? I've gone over this before. The lease is completely void if you fail to pay the delay rental payment, or if you pay it late, or if you pay it in the wrong amount, or if you pay it with the wrong acreage. So that would be then the oil and gas company does not have a lease. The lease gives them permission to be on the land. They don't have a lease anymore. Therefore, they do not have permission to be on the land, and they can be sued for trespass. That is ordinary trespass. That is a right that the landowner would have against the oil and gas company. Another form of trespass is that the situation where there's two people own the property. I'm sorry, these are two separate neighbors, two different pieces of property. And A member drills a well and goes on to B property. That is a suit in trespass. You are trespassing on his minerals, even though you drilled on his own property. The other thing is called geophysical or seismic trespass. That is when you allow someone or an oil and gas company wants to shoot seismic on your land, and they don't bother to ask you about it. They just come on and shoot the seismic so they can determine whether there's oil and gas under the ground. That is a suit in trespass. You do not have the right to come onto my property and shoot seismic without my permission. And the last type of trespass is damage to speculative value. And this is a very important thing to recognize when your geologists are going out and shooting seismic. They need to remember that, and let's say they shoot for seismic and they decide that, oh, there's no value in this land. We don't see any oil and gas potential in this land. And they publicize that, okay? No one then wants to lease with you because this oil company basically destroyed your speculative value. So now it's well known that there's no oil and gas. He's basically deprived you of your right to your minerals. So we're going to sue him for damage to speculative value. It's kind of like a slander. You know, this land is no good. Well, you can't do that. So your oil and gas company that is shooting seismic cannot publicize what the results are. If they have permission from the landowner, they can get those results for themselves. But if they publicize that in any way, they are going to be guilty of damage to speculative value, trespass. Think of it more as a slander of title. Okay, almost done, guys. Implied covenants, I'm gonna mention these to you because we're gonna cover it in a pre-recorded webinar. But even though the lease doesn't say these things, the court says the lease implies these obligations. So the operator has to act like a reasonable, prudent operator. He's got to develop it, he's got to explore it, he's got to protect it against drainage, and he's got to market it. So in other words, someone that just goes out and buys a bunch of leases and hopes that the oil and gas company is going to come along and offer them a big sum and they'll just assign it to them, that's really violating the implied covenant of the lease, because you have a duty to reasonably develop it, to further explore it, to protect against drainage, and to market it. Again, we'll go over those in more detail in that pre-recorded webinar. Okay, and that is our presentation for today. So we talked about the different theories of ownership over time. We talked about the ad caelum doctrine, which said you own from the heavens to hell. Then we talked about the rule of capture, which came along and said if you drill on your property and oil and gas is drained, you have the legal right to that drained property, that drained oil and gas. So the rule of capture says that once you reduce that to possession, once you get that oil and gas out of the ground, you own that land. And then we talked about ownership in place and just plain ownership, and I went over those two different theories, but I don't really see that they matter. Okay, and then we talked about the doctrine of correlative rights. Yes, you have the absolute right to be on your property and to produce land, but you have to consider the rights of the other people in the reservoir. And we do that through following conservation laws. And then we talked about the rights of the mineral owner. And the main right of the mineral owner, well, first they can lease it, you know, they have the executory right, and they have a right to the minerals. And so that is the right of the mineral owner. But the main point from this presentation, the main right that I want to get from explained to you is the right of, or the theory of the dominant mineral estate. And what does the dominant mineral estate says? This is going to be on your exam. The dominant mineral estate says that if the interest is severed, one person owns the surface, one person owns the mineral, B's rights trump A's rights. So we don't have to get permission from A because of the dominant mineral estate. And then we talked about how the landowner could go about protecting their interest. We talked about the different forms of trespass lawsuit and slander of title or damage to speculative value. Briefly went over implied covenants of the lease because in my research, in every oil and gas law article I read, they talked about it. So I just wanted to introduce it to you. Again, we'll cover it at a later time. And that concludes this presentation, ladies and gentlemen. So does anybody have any questions? Want everybody to, okay. Anybody have any questions? You can either say them out loud to me or you can write it in the question and answer box. Okay, I don't see any questions. So I want to thank y'all for coming to this webinar, and I look forward to seeing you in the next one.